Welcome to Conservatorship Basics and Alternatives, presented by the McGinnis Elder Care Law staff. Today I'm Barbara McGinnis, and with me is Tim Takis.
That's me.
And Elizabeth Greer.
That's me.
And we're going to start a conversation about what is a conservatorship and what should we be thinking about. Sometimes we're working with clients or perhaps patients, families, that there is someone that we're trying to take care of and we're concerned that there is diminished capacity, that they may not be making good decisions for themselves. How do you know that the decisions you're helping to facilitate are going to be legal, binding, and ethical decisions? Do you need a conservatorship? Well, first of all, a conservatorship is a court proceeding where a judge appoints a person to serve as a legal decision maker. They're given authority over another person. That diminished capacity, the person with diminished capacity is called the ward, and that person actually has civil rights removed from them and placed in their court-appointed conservator. Obviously, you can see that this is going to be a time-consuming process involving at least one, if not two or three attorneys. So there will be considerable cost involved. And the fact that we're actually removing rights from a person. We're not just making decisions for someone. The reason we have a legal authority over the ward is their legal rights or civil rights have been removed from them and placed with someone else. So this is a process with considerable consequences and should not be considered lightly. We're going to move to the next slide now. So this person-centered planning concept or supported decision-making, if you think that the goal overall here is always to protect our vulnerable adult, how do you begin? Where do you begin? You need to approach this for a care planning and decision-making process in a person-centered manner. What does that person need from you to be able to make decisions, live independently as possible, and live with as much dignity as possible? The American Bar Association has put together a practical tool for attorneys. And that's what we're going to use today to guide our conversation. We're going to go through the acronym PRACTICAL and give you some ideas about how you can help these people.
So we're going to start with P, or presume. It's really important to begin with the presumption that a conservatorship is not needed until proven otherwise. Unfortunately, conservatorships have become a default solution that people mentally jump to immediately, and we want to avoid a bias based on a person's age, their disability, or their diagnosis that makes you or a care-providing family member assume that we need to go to a conservatorship. So under the rules of professional responsibility that govern lawyers, Rule 1.14 speaks directly to whether an attorney is in a setting where they need to think about a conservatorship for their client. When a client's capacity to make adequately considered decisions in connection with the representation is diminished, which could be because of minority, mental impairment, or for some other reason, the lawyer is tasked with maintaining as normal as possible a lawyer-client relationship as far as they reasonably can. When the lawyer reaches the point of a reasonable belief that the client has diminished capacity, is at risk of substantial physical, financial, or other harm, which could be temporary, unless action is taken, and the client cannot adequately act in their own interest, the lawyer may take reasonably necessary protective action to protect the client. In appropriate cases, the rule allows the attorney to consider seeking the appointment of a guardian ad litem, a conservator, or a guardian. But It's serious. This is a serious step to take as an attorney over your client, and it must be based on a reasonable belief that it's necessary, not on a bias or a default judgment that's just based on the person's diagnosis or their age. We really want to think of a conservatorship as a tool of last resort and not the starting place. So we're going to go to our next slide. R is for reason. You must have reasons for conservatorship, and you must begin with, what are my reasons for concern? Am I concerned about the person's ability to manage money? For money management, we could go with a durable power of attorney that allows a capable person to grant another person authority to act for him or her in the case of incapacity. Another option could be joint ownership, but that's not usually recommended. You could consider a trust that allows management of the property for the benefit of the person. You also could consider, is there a person who should be the rep payee for their Social Security benefits? If your concerns are about the person's health care, a healthcare power of attorney appoints an agent who will act in the best interests of the person and base their actions on what they know about that person's ability, what they wanted for themselves in their life, in the way they want their healthcare managed. If your concerns are about the person's personal care and safety, there's a tool known as a mental health declaration that a person can put in place for times when their mental health is compromised. It can be used as a temporary tool, especially for persons who may cycle in and out of good decision-making periods. Then there's shared decision-making, which is a collaborative, patient-centered decision-making process that assists a person in assessing their health-related needs, helps them set priorities, and make choices that achieve their goals. This tends to work better with persons who have some developmental issues rather than with persons who are beginning the process of dementia. And then we're going to go to our next slide.
Ask what could possibly be causing these signs of diminished capacity. Is it something that's temporary or easily reversible? Is there a medical condition that needs treatment, like an infection or dehydration? Are there sensory deficits? Perhaps the person is hard of hearing, not just hard of hearing, but maybe even deaf, and that inability to hear and process communication is making their answer seem nonsensical. So maybe it's medications. Oftentimes, older people are on multiple medications. There could be side effects or drug interactions. So before you're too quick to make a decision that someone has impaired capacity, let's look and see if there are temporary or reversible causes for the situation. Certain psychological conditions, such as depression or grief, makes someone make a decision that seems poor. And there may be ethnic or cultural barriers. Here in the South, especially in our local communities, we are very sheltered and not exposed to a lot of variety in the way people think or speak, and that their decisions may seem strange to us, and it warrants exploring that a little bit further, making sure that we're clearly communicating with them and considering their background. Next, yes. Community. In the community, for someone to continue to live in their home in the community, ask yourself, what would it take for that person to be safe there? What kind of resources need to be mobilized? What kind of securities put in place? Determine if these concerns, your concerns, could be adequately addressed by notifying and mobilizing friends and family to intervene and make accommodations. What are some of the other things that could be put in place, like technology? Sometimes technology is rapidly developing, and there may be a technical intervention that could help allow that person to be safe. medication reminding systems, security monitors, fall alarms that can go on a smartwatch that might detect falls. And even things like the self-driving car is not so far in the future that we shouldn't be thinking about it. And even some of the cars that exist now have, some models have more safety features than others. So I won't get into promoting any one particular car over another, but it is something to be aware of. I think
Next is team. Now, for those of you who have just joined us, we're going through how many letters? Practical. Practical. So we're about halfway through. Team is family and friends, trusted advisors. So ask the person whether he or she has already developed a team to help make decisions. Does the person have family or friends or professionals to help? Has the person appointed a surrogate decision maker to help? Maybe a healthcare agent, maybe an attorney, in fact, under a durable power of attorney. Put together a team. Remember that often our most vulnerable adults, older adults, are the unbefriended or the unsupported elders. I is for identify. Look at the abilities, the strengths and weaknesses. We're looking at now the traditional or classic SWOT analysis. What are the strengths, weaknesses, opportunities, and threats that characterize this individual? What does the person do alone? What do they need help with? Remember that support should be provided only as needed, not necessarily as wanted, or certainly not when it's unwarranted. Often, ability will be situational. In other words, depending on the situation, people may be more capable than in other times or other places. So I guess an example of that, maybe an individual perhaps has just taken medication. Maybe now is not the time to...
Right, they may need, while an acute medical event is going on or after a surgery, they may need extra support and security, but that's a temporary sort of thing. They may need constant supervision to make sure they're not falling. They certainly don't need to be putting anything on their, sending text messages, emails, or social media posts. That might need to be taken away from them. So certain constraints in a temporary situation, but I know we're all really thinking more about elders, right?
All right, so let's look at, C is for challenges or concerns. So now here we're looking for potential weaknesses or flaws in the supports and supporters. So this is really a part of completing your SWOT analysis. So where is the weakness in the plan? Develop contingencies. So for example, oftentimes we see a caregiver spouse who is supporting an unwell spouse. So think about what is the contingency if the caregiver spouse is unable or just cannot continue. Maybe the person has to spend a few days in the hospital. So what are your options then? So make sure that you have a backup plan.
So A is for appoint. We want to be sure that we're helping the client to appoint a surrogate who will act in ways that are consistent with the person's values and preferences. You want to be sure that the client thinks through selecting the best person and not necessarily the oldest child, and certainly not all the children together. As a professional, you then want to do what you can to help the surrogate make person-centered decisions and encourage the client who needs help and the surrogate to have pretty in-depth discussions about the wishes of the client, and then empower the agent or the surrogate to carry out the choices of the person. And then finally, when all else fails and you've done all the analysis and determined that a conservatorship is needed, the most important thing then is to plan to limit the order. You must focus on limiting the rights that are taken away from the person as much as possible, and only take away what is absolutely necessary to protect.
All right.
Questions and comments. We're going to, I think we have a relatively small audience, so we can unmute the lines, but if you have a question that you want to type in, you don't, that would be acceptable as well. We encourage, we have probably at least 10 minutes left if anybody wants to start a conversation.
All right, so everybody, you're all unmuted, so now if you talk, we can listen. So if anybody has any questions or comments, we have a couple of minutes to go. Any questions or comments? Observations? Criticisms? Now, what we are going to do is we will be, we have been recording this, and so we will make it available on our, hopefully on our YouTube channel that you can access through our website.
You know, I know we all recognize that we can, as adults, all of our decisions that we make are not necessarily good decisions. We make bad decisions, and even an older person has the right to make bad decisions. I think so. Making that distinction between, is this a bad decision, or is there a series of bad decisions, or is this an isolated event, or what can we do to help start protecting a person from themselves often, and maybe even from others. I know that we worry a lot about financial exploitation, and that often that worry about financial exploitation is used as an excuse for, or an argument in support of, conservatorships, because of the court accounting and oversight of the courts, judges. That some people think that that is a guarantee that there will not be financial exploitation or abuse of the elder or diminished person with diminished capacity. Do we have anybody with a question? Okay. Pensions that we've mentioned, whether it's a rep payee, a fiduciary through a veterans, overseeing a veteran's pension, a power of attorney, or a conservatorship. Abuse or financial exploitation can still occur. There are no guarantees. So if that person is inclined to take advantage of their elder, they're still going to do so.
You're right. I think the choice of agent is huge. That's one of the most important things. You have to have a good agent and a backup to the good agent.
Okay.
Yes.
Anything else? Anybody question, comments? If not,
well, then we can say goodbye.
thank you all for joining in. As we said, we will have the recording available probably in a few days, hopefully, and we'll be probably sending out an email and let you know that that you can access it. So thank you again, and this will end